Good afternoon. Welcome to Legal Access. We get together Thursdays at this time to give you access to different aspects of the law. Today we're talking about DUI law. If you have any questions about that, please feel free to give us a call. I know we got some more holidays with Labor Day coming up. So if you're going to be out and about, want to make sure that you're safe. The best way to be safe is to don't drink and drive. There are a lot of options out there as far as, ride shares and taxis and stuff like that. However, for the people who are out there and do get pulled over, do want to give you some tips. Now, we're not going to try to give you tips on how to circumvent the law, but trying to let you know what's going on. On the panel here today to answer your questions, we've got Ian McGuire from the McGuire Law Firm.
Good to see you, Dave.
Also to his left, Trent Chambers. Hey, Trent.
Dave, good to be back.
And also from the solicitor's office, Rebecca Benson is here with us. Hey, Rebecca.
Hey.
So if you have any questions, we're well equipped to answer your questions. The phone number is on your screen, 843-848-8080. Give us a call. Again, DUI law is our topic here today with our panel.
Yeah, it's great to have, first of all, Trent back with us. Trent practices here in Myrtle Beach and also has an office in Conway. He does a great job defending people accused of crimes, and he also does some civil work as well. Is that right?
A little bit.
Sometimes we
share it together.
We team up together on cases, and of course Rebecca does a fantastic job prosecuting here. And you're in Myrtle Beach. Are you on 21st?
We're actually in the Conway office.
The Conway office, okay. And the Conway courtroom, is that where you're practicing? Okay, great. So yeah, any questions on DUI law, and of course really anything regarding criminal law, you can give us a call at 843-848-8080.
And Trent, since you're the defense attorney, we'll ask you the obligatory question as far as DUI is concerned. Your advice to individuals about whether or not they should blow the breathalyzer or not?
That used to be a blanket answer of don't blow. If you've been accused, don't blow. But you have to take into account the law changes, and in May of this year, the law did change a little bit in that if you refuse to blow, or if you blow and you blow over a .15, you still get your license suspended, and you can have an administrative hearing on that. But if you lose that administrative hearing, or you don't request one and just go with the flow, you're going to have to enroll in an alcohol drug safety action program, and you're also going to have to get an ignition interlock device in your car. That's the only option.
A lot of people are confused about the ignition interlock devices. They're like, okay, well, what keeps my passenger from being able to blow in the ignition interlock system and say, hey, they're sober, let's go ahead and start the car and go?
Yeah, they thought of that too. So there's a video.
Is there? Okay.
That requires that, yeah.
And do they have to pay for the
installation, maintenance, a monthly fee as well. So.
And how long do they have to have that in their vehicle?
Depends on the situation. It's anywhere from generally 6 months up to 2 years or longer sometimes.
There's also a lot of confusion in South Carolina as far as the breathalyzer is concerned. A lot you see in TV and movies that the trooper has the breathalyzer in his car. In South Carolina, that's not the case, right?
Correct, and there's been cases throughout the country where they did have breathalyzers on the side of the road. The problem with that is each one of those has to be looked at, made sure it's working properly.
Right.
And that becomes able to be challenged in court. In South Carolina, for a long time, it's always been, there's a couple places within the county that you can go. Each police station has 1 or 2 breathalyzer rooms, and they're taken there, and everything's done at the station.
Now, Rebecca, from a prosecution standpoint, what are the main things that you're looking at when a case is brought to you as far as to whether or not this person, is it the breathalyzer, is it the roadside sobriety tests?
So many factors. It's always interesting to me. So, for instance, one of my bosses likes to say with murder, you've got a 2-sentence statute that you're looking at.
Right.
When you come to DUI law, you've got pages and pages, and there are so many requirements there. So for instance, as far as field sobriety goes, there's a lot of different requirements with the camera. I have to make sure that we've got all of those factors so I can go forward and send a potential plea offer to someone like Trent. Or if we've got if the defendant elects to provide a breath sample, then there's additional requirements. It has to be on video. They have to wait 20 minutes. So there's so many things and so many check boxes that we're essentially going through with each and every case.
Going back to what you were talking about as far as pages and pages of requirements as far as DUIs are concerned, a lot of prosecutors look at that in South Carolina and just say there's way too many loopholes that are there. I mean, as far as when the Miranda rights are read, and they have to be read on video and things like that. Is there anything being done? I know the ignition interlock system is brand new as far as laws this past year. Is anything being done as far as loosening the requirements as far as DUI prosecution is concerned?
We're not seeing any changes in that at this point.
I'd take a change in the law, and
Yeah.
I don't think there's been anything proposed.
Yeah, a lot of times we talk about the legal and the moral, and of course the safety reasons for not drinking and driving, but Trent, talk a little about the actual costs that are associated with someone once they are charged with a DUI.
Well, first I want to say you hear from everywhere, don't drink and drive, and that's really not the law in South Carolina. The law is that you can have a drink and get behind the wheel of a car. You just can't drive when your faculties to operate the motor vehicle are materially and appreciably impaired.
Right.
The cost, as you said, if you're dealing, you're dealing with insurance, you're dealing with fines. Fines usually are the least worrisome. That's about $1,000 up to about $2,500. If it's in magistrate's court, if it's in general sessions, you can maybe double those, a little bit more. Insurance is going to be an individual thing. It's SR22 insurance. It's 3 years.
But that's a lot. I don't know.
Yeah, you have to shop around probably.
Yeah.
There's different, like anything, there's different prices. That's a contract with you and the insurance company, so it depends on the individual's probably their record other than the DUI that's causing the SR22. That's the biggest expense. You've got ADSAP, Alcohol and Drug Safety Action Program. That's 8 weeks at least, once a week or once a month for
Attending that class,
Yeah, depending on, once the person's assessed, they can actually do longer. They can actually do several years in that program if they don't assess right. That cost is about $500-600 there.
Getting your vehicle out of an impound.
Impound,
Of course.
not being able to drive, having to
Right.
Uber around and things like that. You hear roundabout numbers of $10,000-20,000 over the long haul.
So it's much more efficient and cheap to go ahead and get yourself an Uber or a Lyft or a taxi or whatever it's going to be. So yeah, go ahead and do that because you can drink and drive, you just can't be over the limit. Now, as far as roadside sobriety tests are concerned, what do they consist of? I mean, it's not like you see in the movies where people have to juggle and run backwards and stuff like that. Unfortunately, because that would be funny if that happened.
The Steve Martin script.
Yeah, exactly. Yeah, I remember that one.
So essentially there's 3 different tests. Your standard DUI, there's going to be 3 different tests. There's an eye test, which is called the horizontal gaze nystagmus, and essentially what the officer is looking for when they use a stimulus, which is typically a pen or the tip of their finger, they are looking to see if the defendant's pupil is delayed in following, and what is that telling them? If it's delayed in following their eye, it's delayed when they're driving. They're missing things.
Right.
They're missing stop signs and things of that nature. Then you've got the walk and turn. Walk 9 steps forward, turn around, walk 9 steps back. The one leg stand,
Right.
hold 1 foot up for 30 seconds. So your standard DUI case, that's going to be the 3 tests that you see.
So gone are the days where you had to do the alphabet backwards and all that kind of stuff.
We don't really see that anymore now.
What about if an individual like myself, I've had some physical, some medical issues where I can't walk and turn, I can't stand on one leg and keep my balance, and my eyes are actually been affected a little bit. If I refuse to take the roadside sobriety test, how is that going to affect my interaction with the trooper?
It depends. Classic answer. They're going to have to take a few factors into consideration. Is there an overwhelming odor of alcohol? Maybe there's something else going on. We do have a lot of times it could be a medical issue. Somebody, we're seeing a lot of older individuals moving down to the area. We might see a diabetic issue at play. So it's really just a case-by-case basis. But there are additional tests that can be performed.
Part of the procedure
Yeah.
is they have to ask, to figure out how old you are. There's
Right.
certain restrictions on that. At certain ages, you're exempt from being able to, expected to do these tests. And they're supposed to ask if you have any
Right.
physical or mental problems that would prevent you from taking the test. Typically, when somebody says yes, I see them still give the test, and then it's up to somebody like me to object to it.
Right.
And go from there. So.
Tell you what, before we run to break, let's go ahead and go to North Myrtle Beach. John has been on hold for a little while. John, hi, thanks for calling in. What's your question for the panel today?
Hey, John.
John, you there? Go ahead.
Okay, this is my question. Can you get a DUI riding a bicycle?
No. You cannot get a DUI riding a bicycle unless it has a motor on it that is that doesn't comply with the law and it's considered a motor vehicle. But at this point, a bicycle is not a motor vehicle under the statute. You can get a public intoxication though. On a
Yeah,
bicycle.
let's go ahead and expand that though, because I know a lot of people ask about mopeds. Mopeds, are they now considered to be a motor vehicle? Because I know up till a couple of years ago they weren't.
Yes.
Mopeds, golf carts, something with a motor. Yes.
Okay. All right, so you're good on your bike there, John, but appreciate the phone call. If you have any phone calls, make sure and get them in. The phone number is on your screen, 848-8080. We're talking about DUI law here today. Going to take a quick little break. When we get back, we'll talk to you right here on Legal Access. Welcome back to Legal Access. We're talking about DUI law here today. If you have any questions, the phone number's on your screen. Give us a call at 843-848-8080. Here to answer those questions for you today on the panel, Ian McGuire from the McGuire Law Firm, also Trent Chambers, and from the Solicitor's Office, Rebecca Benson is here, so please feel free. Either side of the coin, we're equipped to answer your questions. And I know that you actually, Trent, worked in the prosecutor's office as well, correct?
Long time ago.
A long time ago, so yeah. So you've got access from both sides of this equation. So yeah, give us a call here. The phone number again is on your screen as we're talking about DUI law here today. Now a lot of people get upset when they read in the paper or see on television that somebody's been arrested for their 4th or 5th DUI. How do people, get away with being able to get back out on the road after they've had multiple DUI arrests?
Well, the funny answer to that kind of, I'm joking, is that
Arrest isn't a conviction, is that what you're saying?
that and if they are convicted, they get their license taken away, but they still have their keys.
Yeah. Yeah.
So you can drive under suspension and get a DUI, and that's how that happens.
Right.
One way. Other ways is, if they didn't have a conviction, maybe it was a 4th time being arrested, but 3 of those times have been reduced to something else or dismissed.
Do the penalties increase for 2nd, 3rd, and 4th arrests?
Convictions.
And convictions, yeah.
Yes.
And my terminology is not perfect
And
here,
you're
but
jumping
convictions.
if you get a conviction for a DUI first, then you're no longer going to be in the lower court systems and magistrate court. You're going to end up in general sessions.
Speaking of the system, I know that we have very few days where court is in session here in Horry County in the 15th Circuit, along with you, Rebecca. How long does it take for somebody, once they've been arrested, to be able to have their day in court as far as DUI is concerned?
For a jury trial, we tend to say anywhere from 6 months to a year. Sometimes it's sooner than that, but we feel comfortable saying 6 months to a year.
I would agree with that.
Now, Ian, from your side of things here, as far as civil suits are concerned, now if somebody gets arrested for DUI, but they're not convicted of that, yet somebody who was maybe injured in a car accident by the individual who was arrested for DUI but was not convicted, does that affect your civil suit? I mean, they're not convicted of DUI, but your victim is, you're...
Absolutely. It's a good point bringing up that they're not convicted, but, the burden of proof and standards are a little different.
Right.
Beyond a reasonable doubt. In the criminal court, it's a preponderance of the evidence. So you might be found not guilty beyond a reasonable doubt, right?
Right.
In criminal court, but
Right.
in I'll call it our court, in civil court, the preponderance is a lower level of proof, basically. So you could still present evidence, and it's actually more likely that you're going to be able to prove your case in civil court under those circumstances
Right.
than you would and of course the reason behind that is we in a more serious criminal case, we don't want to put somebody in jail that might be innocent, and in a civil court it's mostly about money, so it's a little different.
Now, the acronym DUI is driving under the influence. It doesn't necessarily mean influence of alcohol. So, how does it, as far as prescription drugs or non-prescription drugs, if somebody is pulled over and they blow a 0-0, but they're still impaired, how does that case move forward?
From a procedure standpoint, the police officer, if they have a 0-0 and they expect something else, they're going to go for a urine test. Usually we see a urine test before blood.
Right.
Blood's usually reserved for if you hurt somebody or kill somebody. So that's going to test for everything if they do blood, but urine's going to test for those substances, and I guess the downfall for the prosecution on the urine test is that it's just a positive. It doesn't really show an amount. So.
And just like with a breath test, that defendant's going to have the option to refuse.
Right.
They can be given the option to provide a urine sample, but they don't have to give one.
Well, how does that affect your case if you get a 0-0, but they're acting, I mean, through the dash cam and the body cam, that you can tell that they are impaired?
And I think that's where the importance of having your field sobriety test on video, having your body cam video to show that interaction, the driving on video to show that this was not someone who should have been behind the wheel.
I wanted to bring up the field sobriety test. You can refuse those without a penalty, unless you are charged with felony DUI, and then the statute says you have to perform those, but if you don't, then they're charging you with not obeying a police officer.
A felony DUI is what? Somebody...
Great bodily injury or death.
And as far as refusing is concerned, you can refuse, but be nice about it, right? I mean...
Respect.
Yeah, respectfully refuse. Say, I know that I don't have to, so I'm not going to jump on one leg and all that stuff.
Due to the nature of your employment, we can no longer have a conversation until my attorney's present. How about
That's, yeah. Yeah, write that down, all right, next time. And Trent, I know that I've heard some commercials as far as cannabis is concerned. I mean, if somebody will blow a 0-0, but maybe they're under the influence of marijuana, again, from a prosecutorial standpoint, that's a little bit more difficult, but in the state of South Carolina, it's still against the law.
If you can prove that someone is materially and appreciably impaired, yes.
Proving when that marijuana was in their system is a whole other ballgame.
Yeah, because with a urine test, you're just going to get a positive. You're not going to get an amount. You're going to get a positive. With a blood test, you're going to get, whether it's Delta 9 or Delta 11, whether it's active THC or processed THC, if you will. And those numbers are going to come into a big play. And you're going to find a lot of experts, they're going to say, maybe somebody who has just smoked marijuana for the first time is going to have, very bad results behind the wheel of a car, where somebody who may have smoked marijuana for 5 years, 10 years, they're going to be fine behind the car, wheel of a car, but just any expert's going to tell you that.
Right.
From the prosecution side and the defense side, that's what you're going to hear. When you combine marijuana with alcohol, it's a different story, though.
Yes.
All right, let's go back to the phones here real quick. Let's go to Florence right now. Bill is on with us. Hi, Bill. Thanks for calling in. What's your question today?
Yes, what are the consequences of not taking the breathalyzer versus taking the breathalyzer?
If you take the breathalyzer test and you blow a 0-0 or you blow under a 0.15, you're not going to get a license suspension. If you do blow, or you over a 0.15, you're going to get a 30-day suspension. You're going to have to take ADSAP in order to get your license back. If you refuse, it's a 6-month suspension.
Now, can you get a provisional license if you have to get back and forth to work?
They give you a form that says notice of suspension. On the back, there's a form you can fill out, and you have to mail that in to the state requesting the hearing. You send $200 in right now. That's what the fee is on that. You send that in, and once that gets processed, you are eligible for what's known as a temporary alcohol restricted license. And that's good for a year or until you have the hearing and a decision's made at that hearing.
All right, Bill, thanks for calling in. Appreciate it. If you want to get on and ask a question just like Bill, give us a call. The phone number's on your screen, 843-848-8080. We're talking about DUI law here today. Give us a call. We'll get you on the air. Come back in just about 90 seconds. We'll answer your questions. Any other questions you have about DUI law right here on Legal Access. Welcome back to Legal Access. We're talking about DUI law here today. Again, not trying to give you the opportunity to circumvent the law. We're just giving you information about what the laws are in the state of South Carolina. If you have any questions, we still got a little less than 10 minutes to go here. 848-8080 is our phone number. Give us a call. Now, this might be more of an opinion than anything, but I've heard some defense attorneys say that if you get pulled over by a trooper for DUI, you can pretty much bet that you're going to be arrested for it, regardless of how your field sobriety tests go.
I disagree with that. I have had some, very few, but some individuals approach me and say that they have, been asked to do field sobriety tests and they were let go after that. That does happen. I know that it does. People tell me that. Most of the time when I see people, that has not happened. And that's just the nature of what I do. So typically, if an officer is asking you to get out of the car and perform field sobriety test, he is suspecting something.
Right.
And he is just confirming that with those tests.
Correct.
So
Yes.
typically, if you're asked to do those, you can pretty much count on the fact that he's probably going to arrest you he's definitely going to arrest you if you don't take them. And if you do take them, depending on the results and the officer, you may get arrested, probably.
But in a sense, you might be building a case against yourself
Yeah.
by taking the test.
My advice is don't take those. If you've had anything to drink at all, don't take those.
Now, I know with a lot of moving violations, the police officer, the arresting officer, will be the person going before the judge as a prosecutor themselves. But obviously with DUI, that doesn't happen, I'm assuming?
So a defendant has the option to ask for a jury trial.
Right.
If they ask for a jury trial and it's a magistrate level offense, then it's going to come to the solicitor's office, and then we pick it up from there, and then we become the prosecuting office. So we'll still use that officer as a witness, but we're going to be going forward with it. If the individual does not choose a jury trial, at that point it will be prosecuted by the officer.
The difference being you have a judge as the trier of fact in the law versus the jury as the trier of fact and the judge as the trier of the law.
Now, as far as DUIs are concerned, obviously it goes from, I don't want to say just a DUI, but I mean felony DUIs if somebody gets hurt. What is the threshold for that?
Great bodily injury is what the statute says. And there's a list of things. Basically, if somebody loses consciousness, requires surgery of any point, any part, broken bone, if there's sutures involved, basically, it's going to be charged as great bodily injury. The state also has to prove that there was some other act done that breaks the law, a traffic law. So it's not enough to you'd probably be charged with felony DUI if somebody else caused the accident, you did nothing wrong, and then somebody in your car or somebody in the other car passed away or was had great bodily injury. But the state would still have to prove that the person who's charged did some act that was in violation of a traffic law.
Let's talk about open containers for a second. I know they've adjusted South Carolina law a little bit to where you can go to a restaurant or something like that and buy maybe a bottle of wine for your ride home or something like that. Not to drink on the way home, but to go ahead and take it with you. If the seal has been cracked on that and you get into an accident, yet you're not drinking inside of the car, how can a trooper designate whether or not you have been, or determine whether or not you were drinking because you do have an open container in the car?
It's a separate charge, open container, they're charged with that, and then the DUI is a separate incident that they'd have to prove. The open container just kind of adds to the facts of the case for the prosecution.
Right, so a separate ticket. My advice to the officers always is, whatever you see, charge it, and we'll deal with it later.
Ian, we only have about a minute left, but back to the civil side of things. If you've been injured in a car accident with somebody who has been arrested and now charged and convicted of DUI, that means potentially a lot of money could be coming the way to the plaintiff.
Potentially, it adds another layer called punitive damages that the injured person may be able to receive. I would certainly sit down with an attorney if I was injured by a drunk driver, because like you mentioned, there's a whole nother category, and it basically puts it in a whole nother category as far as resolution and the value of it.
If you have any additional questions about DUI law that you weren't able to call in and get an answer to, make sure and email us. We'll get an answer back to you over the computer. legalaccess@WMBFnews.com. Next week when we get together, we're going to be talking about HOA law, so that's always a lively show. HOAs next week right here on Legal Access. I want to thank our panel here today, Ian McGuire, Trent Chambers, and also Rebecca Benson from the Solicitor's Office. My name is Dave Priest. We'll see you again next Thursday right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the